In the dissenting opinion that you signed on the Ledbetter case, Justice Ginsburg referred to the reality of the real workplace to explain that Ledbetter wouldn't immediately know that her salary was less than her peers.
Title VII was meant to govern real-world employment practices, and that world is what the court ignores today.
My question to you is, when does the Supreme Court consider the real world when interpreting laws?
When does it consider the real world? I think it should always consider the real world. I mean, the document is not written to be in a museum. The document is written to have a set of rules that apply to people today. And so, how it fits into the real world is always difficult. For example, it says here in Article 1 that Congress shall have the power to regulate commerce among the states. When they wrote that in 1787, they didn't really know about automobiles. When they wrote the freedom of speech, no one had a clue about the internet or television. But those words, the freedom of expression or interstate commerce, have to apply today. And to work out how they apply today, you have to take what were they driving at then? What was the point? Why were they writing these things? What were they trying to protect? And then you figure out the kind of thing they were trying to protect, and you see how that applies to the internet. But we're not in a vacuum tube. We're there trying to figure out how these rules of law that are here are going to apply to you.
Justice Ginsburg read her dissent and Ledbetter from the bench and urged Congress to change the law.
Today, the ball again lies in Congress's court. As in 1991, the legislature has cause to note and to correct this court's parsimonious reading of Title VII.
Was it unusual for a justice of the court to address the Congress in this way?
There are two basic kinds of cases we have. One is we'll look at this document here, and it says Congress shall make no law abridging the freedom of speech. And we have to decide whether the Federal Communications Commission, which has a rule about what you could say on television, does that rule abridge the freedom of speech? If the answer to that question is, yep, it does, the FCC can do nothing about it. It's in the Constitution. The Congress can do nothing about it. But maybe, as in the Ledbetter case, what we had was not a question of interpreting the Constitution. We had a question of interpreting a statute passed by Congress. Well, if Congress doesn't like the result of our interpretation, it can pass a new law. What we're trying to do when we decide what a law means is to decide what Congress wanted it to say. Maybe we got it wrong. Well, then they can pass a new one. You want a funny example of what we do in there? I found a good example. I read in the newspaper that there was a biology teacher who was traveling on a train, and he was going from Nantes in France to Paris, where his students were. And he was carrying with him a basket, and in the basket he had 20 live snails, and he was going to show it to the class. So the conductor came up and said, "What's in the basket?" He opened it. He said, "There are 20 snails." The conductor said, "You have to buy a ticket for the snails." He said, "What?" He says, "Why do I have to buy a ticket for the snails?" He says, "Because it says right here in my fare book, it says no person can bring any animal on the train unless they're in a basket. And if they're in a basket, they have to pay half fare." So he says, "That's about dogs." He says, "They're talking about dogs and cats. They're not talking about snails." So the conductor says, "It says animal, doesn't it? It doesn't say dogs and cats. Is a snail an animal?" And he said, "Okay. Did that word animal include snails?" Well, that's a pretty hard question. To find out, you better see what the people who wrote that fare book were up to. Now, why do I give you that example? That's the kind of question that we have when we're deciding what statutes mean. That's the kind of question we had when we had to decide these words. In the Ledbetter statute says she has to bring her claim, if she has a claim of being discriminated against, within a certain period of time. How do you count that period of time? From when? When does it begin? And that's just as hard as the snails. And you could get two different views about it, and it's our view to try to figure out what did Congress really want. And if we get it wrong, Congress is free, certainly free, to pass a new statute. So Justice Ginsburg's in the minority should say, I think the court's wrong. I think this is what Congress meant. But Congress, if you don't like it, you can pass a statute and you can get the same result as I think you meant anyway. You see it? So sometimes we'll say something like that.
Are there ways in which Congress can punish the Supreme Court if a majority in Congress doesn't like a decision made about the meaning of the Constitution?
I think people would frown, the public would frown on Congress trying to punish the members of the court for a decision that they don't like. That was never always clear. When Jefferson was president, they came in, as you probably know, with a new party, what was then called the Republican Party. It's really the ancestor of the Democratic Party. And one of the first things he thought would be a great idea would be to impeach all the judges who had disagreed with him. And the first one he did get successfully impeached was a judge from New Hampshire named Pickering. But Judge Pickering had an unfortunate drinking problem. And he drank so much from the bench that they pretty easily found a lot of litigants who thought he wasn't a very good judge. So they got rid of him all right. But the next one they wanted to impeach was Justice Chase, and he was a pretty good judge. And the only thing that they could find to say against him, the new party, the Democrats who controlled Congress under Jefferson, the only thing they could think of to say against him was that Judge Chase made a lot of decisions we don't like. Same, just your question. Just the question. Well, it was a close call. They voted the impeachment in the House, which is to mean they voted to have a trial. They went to the Senate to have the trial, and Justice Chase won, I think, by a single vote. He was not impeached. And since that time, it has been established, that you cannot impeach a federal judge because you don't like his decisions. Now, that's a very good thing, in my opinion, and not just because I want to keep my job. It's also a very good thing because it makes the judges decide independently. And if judges are going to decide issues where one side or the other might be unpopular, but the Constitution might protect the person who's unpopular, you don't want judges doing just what's popular. So I think that was a good thing. Because Congress is a great expert in what's popular. But the Constitution is not always for what's popular. It's often for what's right in terms of giving people equal rights.